this particular document that you referred to, you've given us 2 pages of it.
Yes,
Have you read the entire document?
I have indeed. I've looked at.
And within the document, I think it carries out a review of all the relevant case law, doesn't it?
Yes.
And what does it conclude?
It concludes that a public body, to establish whether a body is a public body should be judged on its own merits of the case.
What it says is that the case law is pushing towards it being a very narrow interpretation, doesn't it? And the report railed against where the case law currently is, doesn't it?
It did.
Which goes against you a little, doesn't it?
It does indeed, yeah. Thank you, Lordship. May I proceed?
Yes, please do.
Thank you. Well, if your Lordships have no further questions, I will now move on to my second submission, namely that because the court is itself a public authority, it should, in any case, intervene to safeguard the appellant's convention rights. My Lords, may I proceed with my second submission?
Yes, please do.
I refer your Lordship's attention to the case of Regina and United Hebrew Congregations of Great Britain and the Commonwealth, ex parte Watchman, which is reported in the weekly law reports for 1992 at page 1036. This case can be found under tab 5, page 1 of your Lordship's bundle.
Okay.
My Lords, are you familiar with this case?
No. A quick summary is fine.
The applicant was an Orthodox rabbi at a synagogue within the United Hebrew Congregations of the British Commonwealth.
Perhaps you could just bring it to the attention of what point you're trying to make out of this case. That might be quicker.
In this case, the applicant sought leave to apply for judicial review of the Chief Rabbi's declaration on the ground that his decision had been flawed by both the conduct and the makeup of the Commission of the Inquiry. Does that answer your Lordship's question?
You happy with that?
Sorry, what is your point you're trying to make with this?
In that case, the court was establishing whether or not the Chief Rabbi was a public authority in that case.
Okay, and what are you trying to make out of that in your case?
We're basically trying to withdraw from the case because the court the case.
You want to withdraw?
It was a principle that when the court should interfere when a human rights issue does crop up in a body which is either public or a private authority, but that status of the body needs to be established first, which in my opinion was applicable in this case.
Okay.
Does that answer your Lordship's question?
Yes.
Thank you. I would like to draw your Lordship's attention to the words of Justice Simon Brown at page 1041, paragraph D of the judgment. The relevant authority can be found under tab 5, page 2 of your Lordship's bundle. My Lords, may I proceed?
Did he just do that?
Yeah, so just done that one, so that's fine. Do you have any other points to make in relation to that?
That's the...
So we understand that point. Yeah. Have you got any more to move on to?
The only point I was going to make was, in the instant case, the fact that the appellant attends the school under the government's assisted places scheme, it can be argued that this can potentially lead to some sort of governmental interest in the decision to punish the appellant with corporal punishment and the decision to expel the appellant without a fair trial. That was the submission I was going to make, your Lordships.
I think you need to make that submission.
Indeed, yes. I was going to draw your Lordship's attention to the words of Justice Simon Brown at page 1041, paragraph D of the judgment. In the case, Lord Simon Brown stated that to attract the court's supervisory jurisdiction, there must be not merely a public, but potentially a governmental interest in the decision-making power in question.
So governmental interest.
Yes.
So in this case, you've got a private school.
Indeed.
That's not relying on the administrative support of a public authority.
No.
So where's your governmental interest?
the only governmental interest could be argued that is that the fact that the appellant is attending the school via a governmental places scheme,
the
qualify.
government don't make any decisions as to how that school's run.
Well, I'm not heavily relying on the facts of the case, Your Lordship. I'm just submitting it may be argued.
Okay. I'm conscious of time, so
Yes.
any further submissions you've got?
No, thank you. As you've heard on my submissions, Your Lordships, that concludes mine.
Thank you very much.
Thank you.
My Lordships, as mentioned previously, my name is Mr Briggs and I am addressing the second point of appeal on behalf of the appellant, Mr Billy Bunter. I shall be making 3 submissions in regards to the second point of appeal. First, being that whether the expulsion constituted an infringement of the appellant's right to a fair trial under Article 6 of the European Convention on Human Rights 1950. Secondly, whether the caning constituted an infringement of the appellant's right not to suffer torture under Article 3. And lastly, my third submission will focus on the appellant's right to freedom of expression under Article 10. May I proceed with my first point of submission? Article 6 of the European Convention on Human Rights states that in the determination of his civil rights and obligations, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. My Lords, based on the facts before you, the appellant has not received a fair hearing, nor has his case been heard by an independent and impartial tribunal. Instead, the decision to expel the appellant from St Matham's had been made by the party in which the initial magazine article was in fact aimed at. This prompts the assumption that there may have been an element of bias in the decision being made by Mr Wacker. This then further throws doubt over the decision and as to whether it was made using relevant considerations. On the facts of the case, the ultimate decision to expel the appellant was made upon the appellant receiving legal advice and therefore using irrelevant considerations.
In terms of what he actually said, Mr Bunter, or Master Bunter, don't you feel it's fairly apparent that what he did was effectively insubordinate, in that from the facts he alleges incompetence of running the school and suggests he gained pleasure from caning boys at the school? What more does he have to do?
I do take this into consideration. However, I do feel that despite this, he should still be under his human rights, still be given a fair trial, whether that be under an appeal. I know it does state that the appeals are not granted. However, I feel that that also infringes his human rights, as he should be granted an appeal in front of an independent tribunal in order to decide whether or not his actions were worthy of an expulsion.
And what would you say to the fact that he voluntarily signed up to the school's terms?
To that I would like to say that I'm afraid I don't think I can answer that question.
Try.
May I refer to my...
Absolutely.
Of course.
Careful.
Your Lordships, the case before us, he states that he's a sixth form pupil under the government's assisted places scheme. You would assume that his parents may have signed him up to the school as a boy attending the school as an 11-year-old, and as he's progressed, his parents may have continued to sign in onto the sixth form school, and therefore he may not have had any say in whether or not he signed up to the code of conduct of the school. May I proceed?
Thank you.
My Lordships, if I may, I would like to direct your attention to the case of R and Bow Street Magistrate, Metropolitan Stipendiary Magistrate, ex parte, Pinochet, Ugarte, number 3, as heard in the House of Lords in 1999 and reported in 2000 in the Appellate Courts, Volume 1, page 147, which can be found at tab 6, page 1 of your Lordship's finding. Would your Lordships benefit from a brief summary of the facts of this case?
No, just pull out the relevant